Welcome all in this 7-day online National Faculty Development Program on Emerging Trends in Intellectual Property Rights. I'm immensely honored to welcome our DBT South Zone mentor, Professor Dr. R. Rajendran sir, Professor in Microbiology, PhD College of Arts and Science. Welcome, sir. Indeed, I am fortunate to welcome all resource persons, Dr. Kavita Chalakal, Assistant Professor, Inter-University Center for IPR Studies, COSET, Ms. Rati Ashok, Assistant Professor, School of Legal Studies, COSET, Dr. Asha, Research Officer, COSET, Dr. Anson Jose, Assistant Professor, Inter-University Center for IPR Studies, COSET, Dr. Vishnu Shankar, Assistant Professor, COSET, Dr. Chaitanya P., Assistant Professor, SN College. Welcome, sir, and welcome, ma'am, for all your presence and support for this program. I'm pleased to welcome the coordinating college principal, Dr. Beena Jose, Principal, Vimala College. Welcome, ma'am. Dr. T. Shivakumar, Principal, Ratnavedi Subramanian College of Arts and Science. Dr. M.P. Ayappadas, Vice Principal of Ratnavedi Subramanian College of Arts and Science. Welcome, sir. It's my great honor to welcome the DBT coordinator and members of staff from Vimala College for their great effort in the arrangement of this FTP. Welcome all of you in this online platform. I'm delighted to welcome all the members of the staff from RVS College of Arts and Science, Coimbatore, for their participation in this collaborative FTP. Welcome all. Once again, on behalf of Vimala College of Arts and Science and RVS College of Arts and Science, I extend a very warm welcome to all participants in this online FTP. Thank you.
Thank you, sir. Thanks a lot for your words of welcome. And now let me call upon our beloved Sister Principal, Dr. S. Beena Jose, to deliver the presidential address. Over to you, sir.
Commit your work to the Lord and your plans will be established. Most respected Chief Guest of the day, Professor Dr. R. Rajendran, Associate Professor, Department of Biotechnology, PhD College of Arts and Science, Coimbatore. Dr. T. Shivakumar, Principal, RVS College of Arts and Science, Coimbatore. Dr. Kavita Chalakal, Assistant Professor, Inter-University Center for IPR Studies, CUSAT. Dr. Sister Sylvie Matthew, Coordinator of DBT Star College Scheme, Vimala College, Thrissur. Organizing Committee and Technical Committee members, participants from various institutions across India, from Andhra Pradesh, Karnataka, Telangana, Rajasthan, Tamil Nadu, Maharashtra, and my dear colleagues. Today, we have gathered in this online platform for a one-week national level faculty development program on emerging trends in intellectual property rights, jointly organized by Vimala College, Thrissur, Kerala, in collaboration with the Inter-University Center for IPR Studies, Cochin University of Science and Technology, and RVS College of Arts and Science, Coimbatore. It's a joint venture of two DBT Star colleges. Intellectual property right, often referred to as the lifeblood of innovation, has taken center stage in an era defined by digitalization, globalization, and rapid technological breakthroughs. Intellectual property rights refers to the legal rights granted to the individuals or entities for their creations of the mind. It is the driving force behind progress, sustainability, and human advancement. The main purpose of IPR is to protect and encourage innovation, creativity, and the development of new ideas, as well as to reward individuals for their contributions to society. There are different types of intellectual property rights, including patents, copyrights, trademarks, trade secrets, industrial designs, etc. I'm sure that the 7-day faculty development program offers an exemplary platform for all of us to interact with the experts and gain a deeper understanding of intellectual property rights. I take this opportunity to appreciate and congratulate the coordinator, Dr. Sister Sylvie Matthew, organizing committee and technical committee members in conducting this event and acknowledge their sincere efforts in making this happen. Dear participants, your presence will certainly make this FDP fruitful and productive. I wish all the success to the 7-day FDP program on emerging trends in intellectual property rights, and I'm confident that it would be beneficial to all of us. Thank you.
Thanks a lot, sister, for your warm wishes. Now, let me call upon Dr. Rajendran R., Associate Professor, Department of Biotechnology, PSG College of Arts and Science, Coimbatore, to deliver the inaugural address.
A very good evening to one and all who have assembled online platform in this meeting. The most respected, the principal sister, Dr. Beena of the Star College scheme of Vimala College, Dr. Sylvia Matthews, and the principal of RVS College of Arts and Science, Dr. Shiv Kumar, and the coordinator of the RVS College Star College scheme, Dr. Dhanapalan, and all other faculty members, the participants, the coordinators of the various departments of Vimala College, the faculty of Vimala College, the faculty and the staff of the RVS College of Arts and Science, and all other esteemed online platform for this wonderful program on IPR organized by the Vimala College. At the onset, let me first congratulate and RVS College of Arts and Science Coimbatore for this wonderful venture, which is a role model, because you can find that many of the star colleges across the India, you can find that they should come up with such type of the type of your collaboration where you can find that will make many more type of the inventions and innovations to come out in this field as such. Now coming to the theme of this workshop for 7 days as such, you can find that IPR. You know that recently we had a meeting of the advisory of the Star College at Vimala College, and we have been insisting them that they have to conduct the program on IPR. So the day has come, the dream has come true, where you can find that many of the participants who have been really interested in this innovative field has been waiting for it, and then you have made it. So you have taken up a wonderful topic, and then you have put in all your efforts to make this the collaborative program. And I also appreciate the joint venture of the Inter-University Center for the IPR at the Cochin University, which has come forward to give out with more and more number of the topics in which they're going to deal in the case of this IPR as such. Coming to the topic, you can find that IPR, intellectual property right, is said to be something and a creation of the human mind, where the human mind thinks in a different way, and what sort of your innovative thinking the human mind is trying to come out with, and how this creation of the human mind is going to be manifested in the form of your ideas. So what sort of your ideas? The positive ideas which come out, which will try to come out with the different type of your products, or it might come out in the form of your technology, or it might come out in the form of your design. Whatever it is, you can find it is going to give you a very, very value-added type of your IPR as such. And you can also find that it is going to be a statutory right. Everybody whose intellectual knowledge is being put up in the form of the ideas as such, you can find this is a statutory right for the intangible type of your knowledge, which you are going to get it by means of laws as such. So IPR is said to be a very broad domain where you can find that enormous amount of laws and acts have been put forward together in this wonderful topic as such. And you can find that IPR is also going to play a more important role in the case of your industries, and in the case of your business organizations, and in the case of your entrepreneurial attitudes that is being present in them, which is more and more valuable than a physical asset. So physical asset will be only the assets in the form of your buildings and in the form of your infrastructure that is being present. But this intellectual property right is the one which is the knowledge-based asset, which you can find that a property which cannot be snatched away by the others, which cannot be stolen away by the others, but which is said to be something pure one, which will be attributed only to that particular industry or that organization. And you can find nowadays the business environment and the entrepreneurship is said to be increasing tremendously. And at the same time, you can find that the business competitiveness among the Indians is also said to be increasing. So as then more and more of business competitiveness is increasing, you can find that there is also more of competition in the case of your intellectual property rights that they would like to take it up. So now it is a new wealth of different type of your nations. If you take it in the case of your global scenario, you all please understand that India, in terms of IPR, is said to be still in a growing stage, where you need a lot of intellectual people to contribute to this and then to come out with a lot of innovations to be present. In the case of your world statistics, they say that US as well as China are said to be running a race in coming out with different numbers in terms of the IPR as such. But India is said to be in a very, very nascent stage where you can find, in order to figure out in a global condition, we need to have more number of IPR and then more number of patents and more number of trademarks and more number of the intellectual ideas which have been put out in the form of your products to come out as such. And you can find that IPR, when you compare with the olden days, with the modern type of the days that we are taking up, and what is the new era that we are facing in the case of this IPR as such, it has taken a lot of ramifications. It has taken a lot of dimensional changes. And these dimensional changes and ramifications are said to be the one which are putting a deep root into the various fields in the case of your science, technology, engineering, mathematics, or in the case of different type of your subjects that you would like to take it up, and more with that of your science and technology and engineering to be more specific. And this might be in the form of your patents or designs or copyright, as the principal sister was very clearly mentioning about the trademarks, the design rights, trade secrets, as well as commercialization of the different type of your assets, the intellectual property assets and enforcements and systemic efficiency that is being present in the case of each one of them in the case of your production, and also the ratification of international treaties that has been present. You can find that there are a lot of quarantine acts also which have come into role, where you can find that the movement of biological materials, the movement of physical materials, the movement of intellectual property in terms of machineries, how they are able to move from one country to another country is being present. And you know that nowadays, in the recent past, everybody is trying to put their mind into that of your GI, the geographical indication, the geographical tags that they wanted to give into that of your different type of your products that is being present. And each plays an important role in the case of this IPR as such. And you can find that recently, when you talk about the technological development that is taking place in the case of the engineering field, there are different type of your areas like artificial intelligence, robotics, okay, and then the visual type of your effects that is being present, okay, the visual reality, machine learning, as well as blockchain technologies, data analytics. These are all something which are all the talk of the day now. But everything is said to be connected with that of your intellectual property that is associated with that of the advancements in each country and how they are going to intervene and then make them to join with that of the different fields in the case of your biology and different fields in the case of your physical sciences, chemical sciences, pure engineering sciences, and all these things. But take it from me that the legal framework for such type of your advanced fields have not entered into India at all, except a very few. I can give you an example. See, we all talk about nanotechnology, but nanotechnology, you know that it has started at a research level in India, but how far the type of your intellectual rights that is being present in them, the laws, as well as your regulations for the use of the nanomaterials, the nanoparticles, and what is its effect on that of your environment. None of them have come out in the form of your the patents, or it has never come out in the form of your the regulations as such. So it is a big challenge. So what are you going to do? The advancement of science and technology, the modern fields that are emerging out, and how these modern fields are going to match with that of the different areas in the case of your the science and technology, and how we are going to put it in the form of your regulations in IPR is said to be something, a big challenge that the scientists in the case of your India should take it up. And you know that recently you can find that there are a lot of softwares which are coming into that of your existence. And all these softwares, every company was trying to patent it, but it has been totally ousted out from that of your patents. It has been totally taken off from that of your patents, but it has been put into that of your the computer-related inventions and computer-related type of your innovations that is being taken up now. And there is also the data science which has been put up as the topmost table. Okay, so this data science you can find that has been put into a separate type of your area called the data protection bill. So this data protection bill is said to be related with that of your cybersecurity policy, and then various type of your GI tags and all these which have been recently introduced in 2023. So you can find that the IPR, it has become an order of the day. And suppose if you do an invention or an innovation, and if you want to prove that you're said to be something new in this field, then immediately it has to be patented, and only then you can claim the right for it. India lost many of such type of your inventions. I can give you an example in biology. You can find that the golden rice, the basmati rice, which are all said to be the most indigenous products which have been present in the case of your Indian continent, that has been patented in the case of your US. Why? We have lost the chance, and they have taken up a lead in that, and they have taken up a premier effort in that, and they are able to come out with such type of your patents that is being present in that. So anything which is said to be new, and we wanted to claim that which is of our own use, you can find that immediately it has to be put up in the form of your intellectual property right, and then we have to have a claim over it without any type of your intervention from the other countries as such. And in the recent times, there are a lot of refinements which are going on in the laws, and then the regulations, and different type of your the inputs that they wanted to put into that of this intellectual property right. Okay, so this era it has got the power, wonderful power, where you can convert all the ideas and new knowledge into that of your wealth, which ultimately ends up in the form of your social goal or social goodness that we wanted to really take it up. So this current era is bringing in new types of intellectual properties in the field of science, engineering, technology, whatever I have been saying earlier. All these type of areas are said to be something very important. And one more point which I would like to stress here is that with regard to that of your pharma companies, see, there are n number of pharma companies that have come into that of your existence. And recently you can find that during the pandemic, we were all running here and there to get out a vaccine. And what effective vaccine that were able to come out. And how many companies were coming forward with the most effective vaccines that can be given to that of your the people in order to protect them from that of this coronavirus. But only very few companies were successful. And even though you can find that they were not able to pass through the different type of your trials, the clinical trials, but still the patenting was given to them, the intellectual property was given to them, and then a lot of vaccine companies, they were all having a competitive edge over in producing an effective vaccine for this coronavirus. So likewise, you can find necessity is the mother of invention. When there is a necessity, you need to come out with more of inventions. And when you need inventions, you need more of innovations to come into that of the field of research. So you can find the lack of approved vaccines was said to be very less, and later you can find that more and more companies are now working towards coming out with more effective vaccines. This is a good example where the IPR can be immediately implemented whenever it is said to be needed. And also, you can find the government of India is now encouraging all the youngsters, the scientists and the researchers to come out with more amount of innovations, and then to come out with more number of inventions. And they come out with different type of your vision and mission. and you can find that lot of vision of India. So you can find Make in India, Skilling India, Digital India, Clean India, Green India. So you can find that lot of mission and vision has been put forward by the government of India. So all this is said to be the motivating factor, the inspiration that they wanted to give to that of the scientists and the researchers and the common people who will be able to come out with different type of your innovations that is being present in that. So that is going to be the future of this intellectual property right. So there are again still more changes that are going to come in that. And recently you can find in the case of a budget of the government of India in 2023, you can find the finance minister, Mrs. Nirmala Sitharaman, was able to announce that 329 crores have been allotted as a fund on the whole India for creating an IPR ecosystem in India. So you know that this is said to be history in the allotment of budget in the case of an Indian scenario where such a huge amount has been allotted for the people to come out with innovations and with that of a different type of the IPR inventions to be present in that. So the ultimate objective of all is that we wanted to have a more of a creative India and an innovative India. When India becomes more creative and innovative, you know that the ladder in which the India is going to climb to reach the top in the case of your intellectual property right soon will be the topmost country in the world in terms of our intellectual property. So that is going to happen. And that is because you can find that many people that should be knowing about this IPR. So another big challenge is that how many of them are aware about this IPR rules and regulations? And what is the process in which the patenting can be done? What is the process in which the intellectual property can be protected by an individual? So the ultimate conclusion is that the effort that has been taken by Vimala College is said to be something very innovative, where you can find that this is a step for us to spread the awareness of IPR to the common people and to that of your academicians and to that of your researchers, and to make IPR to be totally aware, where it is said to be something lacking among many individuals, which is a big challenge. So ultimately, you can find recently they have also announced that 26th of April should be celebrated as the World IPR Day or IP Day. So all these efforts will culminate in making more and more people to be totally aware about this IPR. So again, I congratulate and I wish that such type of your innovative program should be taken up by Vimala College, even in the case of your future also. And my best wishes and thanks to all the resource persons who are all from the CUSAT in the case of your Cochin, where they have a separate center, Inter-University Center for IPR, and their contribution is said to be something tremendous. And I take this juncture, I would like to thank them for their contribution and with that of your different type of your efforts that have been put forward by Vimala College. So wishing you all the best and making this program to be a successful one in the case of your future also. Thank you for the opportunity. Thank you.
Thank you, sir. We all thank you from the bottom of our hearts for such a beautiful inaugural address. And now, let me invite Dr. T. Shivakumar, the Principal, Ratnavir Subramaniam College of Arts and Science, Coimbatore, to deliver the keynote address. Over to you, sir.
Thank you, ma'am. Warm greetings and good evening to you all. I deem it great privilege to be amidst you all for this 7-day online National Faculty Development Program, flagged by renowned academicians like Dr. R. Rajendran sir, Expert Committee, DBT Task Force member, and former Vice Chancellor, Professor Shabu Thomas, and Dr. Sri Beena Jose ma'am. On this day, I take great pride for the opportunity given to me for delivering the keynote address for the 7-day online National Faculty Development Program. Life is our planet. Life is in our planet is subject to change, and we live in an epoch of modernity which demands new thinking, creativity, idea, knowledge, and the like. Today, ideas as such have become to be known as the intellectual property because of its incorporation, formulation, or reviewing in terms of policies which reflects on greater achievements and thereby sought to assist developing countries on wider developmental objectives. The perception of IP has now gained momentum that it has become important to claim rights for the ideas we come up with. The ideas are not just ideas, and it does not only stop there but are carried forward in terms of implementation and use of a larger scale. This has provoked many new think tanks to create and enhance, innovative, and improvise. The encouragement of such ideas, talent, and skill has involved the identification and targeting of appropriate value adding activities, the development of public and private resources to support innovation, entrepreneurship, and infrastructure development, as well as the judicious use of tariffs and other forms of protections. Sharp increase in the innovation has now become a big task in terms of intellectual property rights. This has led to the demand of the rights that are given to individuals over the creation, and it gives the creator an exclusive right over the use of his her creation. Today, there is an increase in the demand for setting standards and protection of IP rights. The World Intellectual Property Rights Organization has adopted triads of copyright law and set standards in the respective areas. Having all of this in mind, I would also like to make a mention of the various challenges faced by young innovators and entrepreneurs. If we give a hand to enhance, to promote, to motivate and strengthen these young minds, and also to channelize them to become a success in the need of the hour. Apart from this, internationally, the various countries and economics of the world are competing at an index level, which we call as Global Innovation Index, GII. India is ranked 48 amongst of 131 countries in GII. And Switzerland, Sweden, US, UK, and Netherlands have topped the GII ranking, while countries like India, China, Philippines, and Vietnam have bagged the next level in the GII ratings. I would also like to point out some of key indicator in terms of innovation. First one, research policy and facilities. Each and every institution have to create the research policy and facilities. The second one, resource mobilization for research. Next, we have to create the innovation ecosystem. The fourth one, research publications and awards. Fifth one, consultancy and extension activities. Finally, the collaboration. At the higher education level, the college should readily be prepared to provide awareness program, hands-on training, and create experimental laboratories to enhance the innovation process. To name some, the conduct workshop and seminars, research and innovation cell, establishment of incubation center, establishment of IP cells. India is in the process of developing a strong and healthy system of incubation and startups, and the government has also intervened and identified and has also started funding to scale up the process. Under the strong administration and management of the IPR, which is on par with the countries across the globe, India has a keen focus on the regulation and security of IP. Finally, I would like to reiterate that IPR is an integral part of any higher education institution. Quality and excellence can be achieved through meticulous execution of the quality and quantity mission. I request all the participants make use of this opportunity to grasp some ideas and to create and get the patent and to start the startups. Thanks for the opportunity. Thank you.
Thank you, sir. Thanks a lot for your encouraging words. And before moving on to the next speech, I request all of you who are present here to switch on your camera so that we can take a screenshot of the people who are present here. So I request you all to switch on your cameras. Okay, thank you. Now, let us move on to the next person to be presented. The next one is introducing the resource person. I invite Dr. Anjali Kishore, Assistant Professor and Research Guide, Department of Mathematics, Vimla College, Thrissur. Over to you, ma'am.
Thank you. Dr. Kavita Chalakel is currently an assistant professor in the Inter-University Center for IPR Studies, CUSAT, Cochin University of Science and Technology. She had worked formerly as assistant director of research and assistant professor senior grade in Lloyd Law College. She has an experience of more than 12 years in academics and in the national and international non-governmental sector. She received her PhD in 2014 in International Environmental Law from Jawaharlal Nehru University, New Delhi. After completing her LLM in Intellectual Property and Environmental Law 2006, Cochin University of Science and Technology, Kerala, and MPhil in Public International Law from 2008 from Jawaharlal Nehru University. She received her bachelor's degree from Kerala University in 2003. Before starting her career in academics, Dr. Chalakel worked with various non-government organizations. Dr. Chalakel has many publications and presented papers in various international and national conferences. She has also won the Best Paper and Presenter Awards in 2 international conferences. She is a member of the World Commission on Protected Areas and World Commission on Environmental Law, International Union for Conservation of Nature, IUCN. Dr. Kavita was the Fox Fellow to Yale University, USA in 2009 to 10 and a Research Fellow, China South Asia Legal Research Center, China Law Society. On behalf of the organizing committee, with immense pleasure and gratitude, I welcome you, ma'am, for your session. Thank you.
Thank you, ma'am, for the kind words of introduction. I would like to express my sincere thanks to the organizers, Dr. S. Beena Jose, Principal Vimla College, and Sister Sylvie for giving me this opportunity. And I also thank Dr. R. Rajendran for giving such a wonderful introductory talk about the topic we are going to discuss in the next 7 days. And also Dr. Shiv Kumar, I think the principal of RVS CS, for that presidential address. So before I start my topic, I would just like to give a very brief introduction about my center. So Inter-University Center for IPR Studies was established in 2003 as a multidisciplinary center to facilitate IPR research, intellectual property related research. And the center has 3 major wings. One is IPR Facilitation Center, which is vested with the task of facilitating patent filing and any other IPR acquisition for all universities and colleges in Kerala. So it's a service most of the universities and colleges in Kerala can use. So you can approach our cell and they'll facilitate IPR acquisition. Then we have a DPIIT MHRD chair for IPR, which undertakes awareness activities and other things. And I'm part of the academic center of the IUC IPRS, where we offer mainly 3 programs. One is 2-year LLM in IPR. Then we have an integrated IPR LLM PhD program. It's a 5-year course. And then we have a direct PhD program. And our students research in various areas like many of them were mentioned here, patenting in nanotechnology, patenting in biotechnology, patent and stem cell technology, patent and antibodies, genetic resources and digital sequence information, copyright, traditional knowledge, cultural expressions. We have a very, very wide bouquet of flowers in our research area. And that's about our center. Our center is located within the campus of the Cochin University, and it's an initiative of Government of Kerala. So, ma'am, sister, shall I start my presentation? May I share my screen?
Oh, yes.
Yes, thank you. Thank you. So in this class, what I'm planning to do is that basically I'll be giving you an introduction to the categories of IPR, which we have mentioned just now in various speeches by the experts. And then I'll delve a bit more into the patent law, because my colleague would be elaborating on the patenting of biotechnology in the, I think the day after tomorrow, she'll be taking a session on that specifically. So my purpose is here to introduce the whole concept of IPR and how IPR is important to all our academic activities as well as resulting in our technological progress. So IPR is intellectual property rights. It is one of the major economic and market concern, and it has more than $6 trillion value in 2023. It is slightly different from tangible property, traditional tangible property, and it creates an exclusive right. That is, a single person or a single entity is going to get an exclusive right with regard to a particular property. And this is different from monopoly. Sometimes we have this tendency to say that IPR is monopoly and IPR creates monopoly. But those who are from economics background will very clearly know that monopoly is not what IPR is about. Monopoly is more restrictive and it is more focused compared to IPR, which still has some scope of intervention by the government. And one of the major factor about IPR is that it is only given and protected through intellectual property laws within a country. So before I go to the categories of IPR, I just want all of you, I think most of you are from non-law background, I just want you to understand the kinds of property which are there. So normally we study property as movable property and immovable property, or tangible property and intangible property. So movable property is essentially car, or what we say pen, furniture, timber, etc. And immovable property is land, buildings, standing trees, etc. Now the third category which you would see in the slide is called intellectual property, because that is created with your intellect. Intellect doesn't mean that it needs to be high quality intellect. When we are discussing various categories, you would know that it is not high quality intellect which we are talking about, but something which is created by a person's intellectual capacity. And we lawyers have this, I'm a law teacher, and I'm a lawyer. So we have this tendency to justify everything. So we say that what is the reason for giving a property right? That is one question we never ask. We have always learned that private property is owned by a particular person or an individual. But what happened before that private person came into existence? Law says that, is Pavan Pandey, do you have a query or was it by mistake? If you have a query, please type in the chat box. Now, when we talk about property, our first assumption is that it is belonging to someone. But law has an alternate concept which says that before it belonged to anyone, it belonged to everyone. And before it belonged to everyone, it belonged to none. So the question is why the property which was not anyone's property became a particular individual's property. So there are certain theories which propose the justification of this private propertization. First thing is occupation theory, where you say that the first in time to possess is the owner. Then you have the fruit of labor theory, which says that the fruits, which is the things which are the results of the sweat of your labor, should belong to you. You invested your work in something that should belong to you. So that means if you invest your work on something which no one owns, it belongs to you. Then you have a utilitarian concept which says that a property, if it is only owned by an individual or a private property, it becomes relevant to the, it becomes important. Then you have the personhood, which says that your personality is only completed if you have private property. So despite these general justifications, we have to understand that property is basically a term used to indicate the people's access to and control of things like land, natural resources, etc. So property is not a what we say thing which we can hold, but property is known as a bundle of rights. So when you go to any property, you can see that it is coming with a set of rights for you. So these rights include right to transfer, right to exclude, right to use, rent, right to destroy, etc. And now what happens is that when we have this property in our hand, we have these rights which needs to be protected and which needs to be conserved from others. So this is protected only with the help of law. If there is no law protecting property, the assumption is that your property might be taken away from you. So when you own a property, you have the right to transfer, you have the right to exclude, you have the right to use, you have the right to destroy, etc. Then in this context, I hope all of you understand what property is. Property is a bundle of rights which is given to you by a legislative system. Now we move on from the traditional notions of tangible property to the comparatively new version of property, that is intellectual property. So intellectual property basically is identified as what we say, something which is produced using human intellect and which has commercial value. So law only protects those things which has commercial value, and sometimes it also protects your artistic capability, for example, copyright. But what we need to remember is that even though it is known as an intangible property, something which you cannot touch or something which you cannot hold, the only tangible version of a intellectual property is protected. So just because I have a very good idea in my head about a paper I want to write, unless I write the paper and publish it, it is not my property. I cannot accuse my colleague for writing a paper because I was already thinking about that paper. So unless I create it to a tangible fixed medium, my intellectual property is not going to get any protection. So I think one of the speakers spoke about this WIPO. So WIPO is World Intellectual Property Organization. It's basically an international organization which helps in promoting intellectual property protection. May I request Ms. Chitra Veep to kindly mute? Yes, thank you. So intellectual property essentially include the rights relating to, they have given a category of rights: literary, artistic and scientific work, performances, phonogram, broadcast, invention in all fields of human endeavor, scientific discoveries, industrial designs, trademarks, protection against unfair competition, and all other rights resulting from intellectual activity. So what we can see is that they have kept intellectual property as a wide and comprehensive concept where all these things could be brought in. And as teachers, and especially from science background, most of the participants should be focusing more into the classes on copyright law, patent law, patent and biotechnology, and we will have another session on the plant variety protection also. And we have other things like trademark, GI, etc. in the coming days. But you need to understand that just because you are not in a commercial activity doesn't mean that these IP rights are not important. IP rights are very important from a technological progress point on, also your institutional development. I think most of the teachers who are involved in the NIRF or NAC ranking, they know that the importance of publications, the importance of patents in getting your institution ranked. So this is a culture which we have to develop. Even though the government of India is promoting the whole thing, we have to understand that unless we do it at local level, it's not going to have an impact. So as I said earlier, IPR has an abstract nature compared to the traditional tangible property, because it's very easy for us to understand or to say that I have a house. When I have a house, I have the set of rights with me. And these rights include, I can prevent others from entering my house. I can prevent others from sleeping in my house. I can shut the door of my house. I can, rent my house, etc. So when we compare it with intangible intellectual property, there are some sort of abstract nature. But what we have, once we understand this point, that is only the physical embodiment is embodiment or the express form is protected, we can understand the concept of IPR very easily. Because unless the law knows what to protect, it will not protect anything. So for example, when we are going to look into copyright, we will see that ideas are not protected. So let us take, for example, the idea of family or the idea of friendship. We can see that the idea of friendship has been reflected in many fictions and many non-fictions, many dramas, musical works, or cinematography. All these forms of creative expressions have spoken about friendship. We have read multitude of novels about friendship. We have seen multiple movies about friendship. Same goes for the family system also. Like we have so much of family movies in whichever language you take, almost all family movies would have the same idea or the same concept. But each family movie will be different from the previous one, because even though the idea of a family remains same, the expression how the familial relationship comes out is different in each movie. So unless it is physically embodied, unless it is expressed, the law will not protect IPR. So there are a couple of things which we need to remember when it comes to the nature of IPR. First thing is that IPR is protected under national laws. That means if we need a patent law, we need a copyright law, we need a trademark law, we need industrial designs law, we need geographical indications law, etc., to protect those categories of IPR. Just because we have some idea or I have invented something doesn't mean that I have a patent in that. I need to go to the patent office. I need to get it registered according to the procedure. And only then I can claim that I have an exclusive right in that particular patent or particular invention. But what we need to remember again is that even though it is controlled by domestic law or the domestic legislations, these domestic legislations are to be in pari with the international law. So I think most of the teachers here would know World Trade Organization, WTO. And when India became a party to WTO in 1995, we were mandated to make all our laws in compliance with the WTO system, which included IPR also. So even though we are protecting it under the national legal system, the national laws are in compliance with the international legal system. And we need to understand that even though we call all of them in a combined mode as an IPR, the nature of rights granted to each of this category is different. And this is different according to the subject matter of protection. So copyright owners will get a set of rights, patent owners will get a set of rights, trademark owners will get a set of rights. So each type of IP is different, and the subject matter that can be covered in the time frame of protection and total expense for acquiring that particular IPR. So although some inventions may be covered by multiple types of IP, it is always important to identify which one do you want to protect under. So for example, patent will give you a stronger protection, but copyright will give you a longer protection. A trademark will give you infinite protection. As long as you renew it, you will get it. So you have to look into the category of your IPR or your intangible property or intellectual property and get a protection accordingly. So we need to know that it seeks a balance between private interest and public interest. That means so for example, when I'm taking a patent, I'll get a patent for 20 years. That means for 20 years, no one else can touch my invention. Only I can commercialize it. It is a sort of exclusivity given to me. And that means I can decide the price. I can decide the number of items which I'm going to be make available in the market. And law always says that such sort of exclusivity would be always a problem. So law insists that if you want a patent, you need to give in writing the entire thing about your invention, so that after 20 years, this particular detail will be available to the general public and they can start creating new technology on that. So even though we are getting an exclusivity for this IPR, what we need to understand is that it would result in what we say, it would result in the knowledge becoming a public domain after the protection is over. So, sorry, IPR is a prerequisite for better identification, planning, commercialization, rendering, and thereby protection of invention or creativity. So basically, you can say that once you have a strong IP system, It is said that it will promote innovation, it will promote creation, and it will increase the commercialization, protection, and enforcement is much easier. Enforcement means you can prevent others from using your intellectual creation through IPR laws. And I have just told that we have multiple types of IPR. And are there any questions till now, or shall I move forward? If there are no questions in the box, I'll just move forward with the. Okay, there are no questions. So what we need to understand is that there are different types of IPR. As I said, there are different categories, but basically it is divided into two major categories, as you can see on the screen. One is known as the industrial property, and the second one is known as artistic property. So industrial property are those categories of IPR which has an industrial application. So patents, trademarks, industrial designs, geographical indication, plant variety protection and farmers' right, trade secret, semiconductor chips and layouts, etc. fall under the category of industrial design, industrial property. And then you have the artistic property, which is in related to copyright and related rights. So what I would like to mention here is that all these subcategories have their own specific legislations or statutes or laws to protect them. So what is to be patented, what could be trademarked, what is to be given a protection under industrial design, what are copyrightable works, etc. are given in the copyright or the relevant laws. So these laws essentially provide you with the right. And we'll just glance through the major categories of IPR. The first one is, I kept artistic property because it's just one category. And under that, we have the copyright and related rights. So copyright essentially began with the invention of printing press, because it was basically the necessity of protecting the printers which gave rise to the copyright law. So we can always, euphemize and say that copyright was a protection of author, patent was for the protection of inventor. But in the innermost concept, we can see that these law always protected those who are investing their money or those who have more commercial interest in that. So basically, before the printing press, it was copying by hand. So the number of copies available or the speed of copying was very slow. But with printing press, it became quick and faster. And I think in the modern era with Control-C, Control-V, I don't even have to say, like at least at that time, you have to switch on the printer and get things done. Now we open one document on the other side of the laptop and we just split the laptop and we can copy paste directly from here to there. So the printing press necessitated the protection of the copyrightable works. And again, it includes a bundle of rights. So these rights are relating to reproduction of the work, communication, adaptation, and translation. So reproduction of the work is making copies of the work. So that means I can always buy a book and read it. I can always give it to someone. Someone can borrow from my collection to read it. What I'm prevented from doing is that I cannot make a copy of that book and sell. Reproduction means basically making another copy of the work which is protected. So all photocopies are reproductions. All downloads are reproductions. All sending by attachments, adding to drives are reproductions, which are by law an offense. However, identifying the reason or the need for meeting the public interest or the public welfare, the law has given certain exceptions. And law says that for educational purpose, you can always use any copyrighted material. So I'll be down the presentation in 2-3 slides. I'll be coming to that. So basically, I want to say that reproduction is one right which is given exclusively to the owner of the copyright. Second one is communication to the public. Communication to the public basically means my communication to the, so this is a communication to public. I'm delivering a lecture. That means it's a communication to the public. Or I'm reciting a poem, or my cinema is being shown, or my book is read, or my drama is being enacted. That is all communication to public. And then we have the adaptation. Adaptation basically means you are adapting one form of the copyrighted work to another form. For example, Harry Potter novels, which became Harry Potter movies, or any particular novel or any fiction which became a movie, etc., or a drama made into a movie, all those things. And last is a translation. So these rights are provided to a copyright owner when he registers his work. But copyright is the only category of IPR which does not require registration, because even an unregistered copyright can get a protection for you under a common law system. For example, I wrote a book, theft or cheating, so I have remedies under that also. Now, when we talk about copyright, as I said earlier, it is only the protection of original work. And original work doesn't mean new work or novel work or the first time work in the world. Original work basically means originating from the author. So if I am the author, I should have written that. I should have drawn that. I should have written, or I should have enacted, etc. So basically, the originality is it should be originating from the author, and it should be in fixed form. That means it should be in a tangible medium. If it is a music, it's not just a tune in my head. It should be fixed to a phonogram, or it should be fixed to some sort of medium. If it's a novel, it's not just an idea in my heart or my head. It should be written into a paper. So what we need to remember here is that copyright law is never concerned with the originality of idea, but with the expression of thought, as I gave the example of family movies or friendship movies earlier. And here the result is that only thing is that the copyright is given when there is a substantial independent skill and creative labor or judgment. So there should be some sort of creativity which would be resulting in originality for you to get a copyright. I'm not going in detail to these rights because you'll be having a detailed class on these rights tomorrow. Basically, there are two rights. One is economic right. That means anything which will make you money belongs to the category of economic rights. Then you have the moral rights, which is basically given to the author to be called as the author of the work, to ensure that no one destroys my work. And these are inalienable. Economic rights can be given to someone. I may write a book and I may transfer the rights to DC Books or National Books, something like that. I can give it to a publisher and they will publish. But moral rights are something which is always vested with me, and I won't be able to transfer it. Then we have ownership of copyright. One of the peculiarities of copyright is that it has two members to it. One is the author and the other is the owner. So the law always says that author is the first owner of copyright, but author can always transfer his ownership. So in case of literary, dramatic and musical work, it's author and music composer. So even if S.P. Balasubramaniam is singing or Yeshudas is singing or Chitra is singing, the song belongs to the composer, who would be A.R. Rahman or Ilayaraja or someone who is composing the music is the author of musical work. When you have an artistic work other than photograph, that means sculpture, painting, etc., the artist is the author and the first owner, but he can change it. Photograph is the person who is taking the photograph. A cinematograph, film or sound recording, the producer, the director is not the author. But there is very strong debate in the law asking the director also to be recognized. They say that producer just gives the money. It's the director whose vision and art becomes the movie. So the director should be given a right. And then we have the literary, dramatic, musical or artistic work, which is basically computer generated. Now it is a time of AI. Most of you are very familiar with AI created images, AI created works, etc. So in such cases, this person who causes the work to be created. So as of now, law does not recognize artificial intelligence as an author. It is basically the person who is behind that particular program who is given the authorship and ownership, which could be changed. The duration of copyright is lifetime plus 60 years in case of literary, musical and artistic work. 60 years from publication in case it is an anonymous work or pseudonymous work, posthumous work, cinematograph work, government work, international works, etc. And performer's right. For example, if, as I just said earlier, Kes Chitra is singing a song, Chitra has a performer's right for 50 years, but the authorship right always vested with the composer. And formality is always for the protection is only given what we say formality through registration. Even if you do not register, you have remedies if your copyright is violated. But please remember, it is only for copyright that you have these remedies. For all other category of IP, you have to have a protection under the particular law. And the major issues which are related to copyright are basically plagiarism, sharing. We don't even think, like, you get a video in WhatsApp, you don't even think who is the owner, you immediately forward it to others. You keep a WhatsApp status, you don't know from whom that particular photo originated. We send it, and this daily we are doing multiple copyright violations, and that already, it's always said that copyright is the most violated IP, but the least disputed, because no one is going to fight for you for sharing an image or something. But then the illegal downloads or the infringement, plagiarism happening through infringement, cut paste, which we all do in not I'm saying which we all do, which we are all very familiar with when it comes to the writing of writing submitted by our students. Earlier, at least we could ask them to write in hand and submit, but nowadays they submit in the soft copy. So copy pasting is much easier. And now you even have the dictate and say, so you don't even have to type or copy paste. You can ask the computer to do it for you. So these are basically the issues of copyright. And then, as I said earlier, in certain cases, law says that you are able to use a copyrighted work provided you are not making money out of it. So if it's for an educational purpose, if it is for publication in the news, or if it's for a review, or if it is for the parody, if we are using it for parody, or if we are using it for research purpose, or if we are using it for interoperability purpose, etc., copyright permits you to continue with your continue with the use. But the moment you start making money, it is a violation of the copyright of the original owner. So with this, we are moving on to the next big category of IP, that is industrial property. And I'll start with trademark. Trademark is essentially a sign which is capable of distinguishing the goods or services of one enterprise from the other enterprise. These are protected by IPR, and it could be a word mark, it could be a service mark, it could be shape mark, and you even have the non-conventional mark called smell mark or olfactory marks. So you can, when we see Tata as the T is there, we immediately identify it to Tata. So there are many very famous, trademarks. And this trademark protection is possible only when it has particular characteristics. So there is a spectrum of distinctiveness where you have generic terms which will not get you any protection. Descriptive may be protected, may not be protected. So for example, generic is bleach, sugar, etc. Or descriptive is cold and creamy. We all know that ice cream is cold and it is creamy. And then spray wash, which when we see a spray nozzle and a knob in with it, we know that it is going to be a spray wash. And then we have suggestive, like for example, Greyhound or Jaguar, which shows the speed of the vehicle. But then, from suggestive onwards, we have a higher chance of protection. So arbitrary, like it may not have any relation to the thing. Apple, for example, or BlackBerry. Then we have the fanciful ones like Google, Exxon. Google doesn't mean anything. We may have assigned multiple, full forms for Google and Adidas, etc. But essentially, those doesn't have a particular meaning, and they are the most distinctive when it comes to the protection, and you can easily get a protection for that. So basically, it could be a combination of words, letter, numerals, or drawing, or it could be fragrance, etc. Anything which is used as a mark to indicate the origin of that particular product and has acquired a distinctiveness is protected under the concept of trademark. So one of the examples which I always use in my class when it comes to trademark is, we all rush to the shop and ask for a Bisleri. Suppose it's a very hot day and you're traveling by train and you don't have water, you immediately rush out and you purchase a bottle of Bisleri and you come back. And in the train, once the train starts from the station, you would realize that it was not Bisleri, it was Belseri or Bilseri or Brisley, because it's easy for us to fool, because the moment we see a sea green logo and a sea green cap, we assume that it is Bisleri. Almost all of us sitting in this particular group would have at least fallen prey to the trademark infringement at least once. I still remember in my childhood, the Eclairs chocolates were very a bit expensive and a bit difficult for us to get. But every small shopkeep will have an Eclairs, and you buy it for the price of normal Eclairs. And when you get the Eclairs in your hand, you would see that it is not Eclairs, it was Escalate or Escalar, etc. So by a mere change of words, we would be easily fooled. So there are some deceptively similar trademark. For example, Puma and Comma. If you are not very clear about the tiger or the Puma or the big cat facing where, you would be very easily confused about that. Or Nike or Nuke, or Starbucks and Sardar Baksh Coffee. So these were all cases which came up before the court where there was deceptively similar uses of trademark. And this will be in detail taken in another class. I'm just introducing the concept to you. Then we have the third category, that is geographical indication. Basically, geographical indication is an indication which identifies a good, a particular product to a particular geographical location. So there is a particular quality or a reputation or a characteristic which is attributable to that particular geographical origin. So we are all familiar. We all may be using one or two GI protected products. For example, Kanchipuram silk saree, Nagpur orange, Palapuri chappal, Palakkad matta, Marayur jaggery, Aramula mirror, Pokali rice, Balramapuram handloom. And recently, I think in Tamil Nadu, I think last week, a type of banana was again GI. I think it is in southern Tamil Nadu, the erstwhile Travancore region. And I think it is Matti Pada. Something like that have been given a GI just last week. So this is essentially linked to a particular location. So for example, Champagne is always to the Champagne village in France, or the when we take tea, we have so many types of teas which are available, and almost all of them are GI protected. For example, the Nilgiri tea is known as Nilgiri Orthodox, Darjeeling, Nilgiri CTC. Then we have Assam Orthodox, Assam CTC, etc. Basically, this is located to a particular region. Now, one of the most sometimes we may even find very interesting struggle between states to acquire a GI. For example, Rasgulla, which we all call the white spongy ball thing, very sugar, very, very sweet thing. There was a very big tussle between West Bengal and Orissa with regard to who owns the GI of Rasgulla. West Bengal said that it is Rosgulla, which was created in West Bengal, and Orissa opposed it, saying that it was made in Odisha before West Bengal. So finally, the GI registrar has given West Bengal Rasgulla and Odisha Rasgulla. So you have two Rasgullas now. But basically, at that time, we were confused. Why are you struggling over a food product? So this goes on, one of the most common fights which always happens is with regard to food products. Or, for example, I think the biryanis which we eat, Lucknowi biryani, Hyderabadi biryani, Calicut biryani, we have those struggles and all those things. But what we need to understand is that basically all these things are protected because they have a link to a geographical location. So the question is, does a Kanchipuram weaver sitting in Kerala weaving a Kanchipuram sari can create a Kanchipuram sari? Technically, yes. Legally, no. Because Kanchipuram sari can only be produced from Kanchipuram village. That is how the GI is given to that particular product. So basically, it works through a society, and the society like Kanchipuram Weavers Society would be there, or Palakkad and Matta Rice Growers Association would be there, Pokali Rice Growers Association would be there, Basmati Rice Growers Association would be there. So all this association tells who can grow these type of varieties and how can you protect it. The next category is industrial designs. So industrial design is slightly different from patent and other categories. Industrial design essentially tells you how you're protected. So you all have water bottles. I always use water bottles because it's something which was very much part of our life. And we all buy water bottles not just because you need a water bottle to carry water or a drink water. That is, of course, the purpose. But we always purchase bottles which are cute to look, which are pretty to see, which have vacuum pressure, which will keep cold water cold, which keep hot water hot, etc. So basically, it looks into the aesthetic part of the particular product. So, for example, how a particular bottle is shaped, or how that particular, for example, fashion design. Almost all fashion design categories fall under industrial design. Or you may be buying those plastic vessels, for example, Tupperware or Signora ware. All of those designs are protected under industrial designs. The look of a car, the design of a car is protected under the industrial designs. So you have multiple types of things which are applied as an ornamentation protected under industrial designs. But what we need to remember is that only aesthetic designs are protected. If it is not aesthetic, if it is not functional, you may not qualify for a protection under design. So all these things, their shape, their what we say, the design. So even if you buy Bisleri or Aquafina or Pepsi water bottles, you would see that all those water bottles have different shapes. All of them are protected under the category called industrial designs. Toothbrush, the design is protected under designs, or all these things. So for all examples of shoes, the t-shirts you wear, the dresses you wear, the Sabyasachi, Gucci, all those Dolce & Gabbana, all of them falls under this Industrial Designs Act. And the next variety is plant variety and farmer. The next category is plant variety and farmers' rights, which again we will be dealing in detail in the next class. Basically, this gives protection to plant varieties which are created by farmers or by breeders, and they have certain set of requirements to fulfill the protection to get a protection of plant variety. It is basically for 15 years for annual crops and 18 years for trees and vines. So this we will be discussing in our, I think, second last class. Next, we have the major, the major part of my protection, that my presentation, that is patent. A patent is basically a statutory right. That means it is a right given by a law, or an exclusive right given for an invention. So an invention which is a product or process could be given a protection. So it could be a product or a process. So I always use this example: 3 plus 3 is 6, and 3 plus 3 is the process, and 6 is the product. Under the current patent law, you can protect both 3 plus 3 and 6. So both product and process is protected under the patent law. And basically, you need to give the explanation, the disclosure about your invention to the patent office for the patent office to give you a protection under this particular law. You get 20 years of exclusive right from the date of application. And one of the, the earliest patent is, this is not something new. Earliest patent began in 1291, or sometimes they say it is in the 14th century or 13th century. These were given to the monopoly rights were given to the weavers, the cloth weavers. And basically it was a privilege given by the king to the new inventors. And Venice, the city which was built on water, was the first state to create a law for patent protection. And it protected, it protected any invention which was used in the building of the city of Venice. And we need to understand that patent can be granted for anything which we may not find very innovative. At one point, that is 1982, the bathroom tissue holder was something new, and it was given a patent. And in 1896, a lemon squeezer was found to be new. it was given a patent. Nowadays, we don't find, I mean, lemon squeezer is something very easily attainable or available, but that was also given a patent. What we need to remember is that it is not something which should qualify our requirement. It is basically, it should qualify the requirement for the state. So one of the world's first instant noodle, the cup noodles, was actually brought to the global market through patents. So like, this chicken ramen and the cup noodles, which we still use. Now they don't have a patent because patent is only for 20 years. These type of things were brought out into the world because of patent system. And I would just like to give example of patents which were granted. In 1907, a toothbrush was given a patent. The design of a toothbrush was given a patent. Later on, you can see how these things developed. I mean, I preferably like the left side toothbrush, which looks easy to brush. I don't know, but then that is a type of brush which was proposed. Then you have a brush with the bristles attached to a spring. Maybe it will give you good reach into your mouth. And then in 1940, we have an electric toothbrush being protected. And nowadays we have all in one toothbrush where you can just keep the paste and it is electrically charged. You can just use it and the paste will automatically come to your bristles and you don't have to squeeze your paste in the morning and do that. So what qualifies or what makes a thing capable of patenting? So in law, we have this concept of standards for patenting. Basically, it should be an invention. A patent is only given for an invention, and an invention could be for a process or for a product. It doesn't matter. Previously, from 1970 to 1995, considering the health security and the food security issues in India, the government of India, through the Patent Act 1970, did not give to product patents to two categories of invention. One is pharmaceutical products and second was agricultural products. Both these products were given an exception under the patentability criteria. So this essentially led to India becoming one of the biggest pharmaceutical manufacturers in the world. That is, we were called the Global South, pharmacy of the Global South, etc. So essentially, let me go back to my 3 plus 3 is equal to 6 example. So in 3 plus 3, if it is a pharmaceutical product, if it is 3 plus 3 and 6, only 3 plus 3 is protected. 6 is always open for me to reach on another way. So it can be 4 plus 2, which is resulting in 6, or it could be 8 minus 2 resulting in 6. So only thing was that I cannot use 3 plus 3, but I can always create 6 by some other methodology. So this is how the very popular and very, public welfare element embedded concept of generic medicines came out. And these generic medicines actually brought the prices down, making the pharmaceutical products more accessible, available, and affordable to the general public. So only after we became a part of TRIPS, WTO in 1995, we were asked to make our law applicable to all type of inventions. That means regardless of product or process you were supposed to give a patent protection. So now we give process patent and product patent for all categories. And previously we had left 2 out of them, that is pharma and food industry, agricultural industry. So even when you are having a product patent or a process patent, it should have 3 steps. It should have 3 qualities according to the Indian Patent Act, and only then your invention will be considered for patent application. First thing is that it should be new, it should have an inventive step, and it should have an industrial application. So a patent means a patent. This is the only slide which has some sort of flaw, and I request the participants not to please be patient with that. I just want to tell you what it is. So invention, I said in the previous slide that it should be new, it should have an inventive step, and it should have an industrial utility. So here we will understand what is new invention. An invention which has not been anticipated, which has not been expected by anyone, is called a new invention. So when you are working in science, you would very clearly know what is an anticipated invention and what is not an unanticipated invention. So a new invention means it is something which has not been in the prior art, and it does not fall under the public domain. So it is something new which was not previously existing in this world. An inventive step means it should be there should be some sort of improvement from the previously existing version of that product. So for example, we had landline phones at one point in time, and now we have smartphones. Look how the technology has changed, both our phones. But now with the smartphone in your hand, you don't need a camera, you don't need a calendar, you don't need a clock, you don't need a radio, you don't need a TV, you don't need cable connection, because your smartphone is capable of doing all those things. So inventive step essentially means that you have some sort of improvement over the existing one. So it should be an improvement on something known before, or a combination of different matters already known. And it should be more than a workshop improvement. And the purpose is basically to encourage scientific research, new technology, and industrial progress. And patent actually gives you an exclusive right to own, sell, use, etc. for 20 years. And for you to get that 20 years, when you are applying for a patent, you have to give the full details of your invention, which we will just come in 2-3 minutes. We'll reach that slide. So when you get a patent, you have the right to sell, assign, and license. As I said, in case of tangible property, you have a set of rights. The same set of rights are applicable when it comes to the patent also. You have the same, you can give it to someone, you can sell it to someone, you can rent it out, etc. And now, because we have discussed that patent gives you a sort of exclusivity, what we need to know is that why is everyone so scared of patent? Because usually patent has a negative connotation, especially in the public platforms, or when we compare welfare to patent, we always say that patent is against public welfare, because patent is creating an exclusive right or a limited monopoly. So that means the prices could be very high. So to counter this patent, we call it as patent abuse. To counter this patent abuse or malpractices by the patent owner, our law provides multiple venues through which you can always counter it. And one such venue is compulsory license, where I have a patent. I'm just giving an example. I have a patent, and I am charging a very high price for it. That means no one can purchase it. But then the government intervenes, and the government takes away my right for a limited period of time to meet the requirements of the general public. So I'll just give a case, which is an interesting case for all of us to understand, where compulsory license or a patent abuse was prevented by the court. So this is related to a drug called Nexavar. Nexavar is marketed by Bayer Corporation, and it is for stage 4 renal cancer. So it's basically the stage 4 cancer means it becomes a life-saving drugs. And the company was marketing that drug for 2,80,000 per course. That means for 1 month, you have to pay 2,80,000 rupees. And with the population in India, you know how many kidney cancer patients or liver cancer patients are there. And we know that in reality, it will not be possible for all of us to afford 2,80,000 for a single course of a single drug. So the question is, even with that high price, around 17,000 people were ready to purchase that particular drug. So the market demand was 17,000 who were ready to purchase, and the value was 2,80,000 per course, and it was a life-saving drug. But the Bayer Corporation only gave it to, I think, 13,380 or 1,480 patients. They did not even give it to 10% of patients who were requiring that particular drug. So in this context, the government came in with a concept of compulsory license, where it says that if the reasonable requirement of public with respect to the patented invention, that means reasonable requirement of the public has not been met, the patented invention is not available to the public at a reasonably affordable price, or the patented invention is not worked, that means not performed in the territory of India, this can result in your patent being taken away for a period of time. And here, the company, the Bayer Corporation, which was not ready to give the medicine for a the number of required patients or the amount in which was affordable, the Natco company, it's another pharmaceutical company, proposed that they are ready to produce and market the product for 10,000 rupees per course. So you can imagine from 2,80,000 it is coming to 10,000, and they wanted to they wanted to sell it for 10,000 rupees. So first Natco approached the Bayer company. Bayer company said no, because you can imagine, I mean, the loss of revenue they are going to have, it was huge. So they said no. But then the Natco approached the patent controller and the other governmental forums, including the High Court and Supreme Court. And finally, it was decided the drug was to be given in compulsory license to Natco, but not for 10,000 rupees, but for 8,900 per course. And it was also stated that Natco should give free drug for at least 600 patients every year as a part of this compulsory license. So this compulsory license is actually an encroachment or a trespass into the rights of a patent owner. But then it is not easy to get a compulsory license. It will take a lot of efforts and time for you to get the patent. So there are certain things which are not patentable in India. Section 3 gives you the details of what are not patentable. So anything which is frivolous or contrary to well-established natural law, something which is contrary to public order or morality, something which would seriously affect human, animal, plant health or the environment, a mere discovery of a scientific principle, or discovery of any living thing or non-living substance already existing in nature, discovery of a new form of a known substance, an admixture, an arrangement or rearrangement, a method of agriculture or horticulture, diagnostic or therapeutic method, plants and animal in whole or part, mathematical business method, etc. are not protected under patent law. And other categories which is already under copyright law, or topography, that is integrated circuits, or performing traditional knowledge or methods like that, are not protected under patent system. So when we have a patent, very quick discussion about the grant process. The first is, once you have a concept developed, you do a patent search to see whether it has already been in the patented category. And if it is not in a patented category, you can start drafting your patent. Then you file your patent to the respective patent office. We have 4, one in Chennai, Delhi, Bombay, and Calcutta. So for South, it is in Chennai. And once you file, the patent application will be examined by the patent examiners. And then there is a process where it will be published. And if anyone has a problem with your, if anyone feels that, that you have stolen his idea, he can oppose the patent before the grant of the patent and after the grant of patent. So if there is a pre-grant opposition, if you are being opposed before the grant of patent, your pre-grant, your patent might be taken away. Then if you are granted, there is still a gap of 1 year within which anyone who is interested, any interested party can question your patent. If there is no opposition, you will be given a patent. If there is an opposition and you have cleared the opposition, you will get a patent. If you do not clear the opposition, you will not be getting the patent. And with this, we come to the last category of our IP, that is basically trade secret. Trade secret is not technically an intellectual property law protected category. It is protected through contract law. You will be entering into non-disclosure agreements, NDA agreements, when you enter into any type of job. So trade secrets are essentially protected under such confidential contracts, or you might not even know. Only one person would know what is a particular combination. So it could be an invention, or it could be chemical formula, recipe. For example, KFC chicken, we all know that KFC chicken, that KFC is a trade secret. Coca-Cola syrup, that combination is a trade secret. But one of the biggest trade secret is the algorithm of Google search engine. This is one of the most famous trade secret, because the problem is, if you patent it after 20 years, it will be part of the public domain. If you copyright it, it is always again open to public. Anyone can reverse engineer and use it. So to prevent that, most of the companies, if they want to protect their data, their information, they protect through contract agreement known as trade secret. So Google algorithm, the search engine Google algorithm, is a trade secret. it is not protected under any written category. So we don't know what the algorithm is. That is why whatever search engines come up, they can't match up Google Chrome. They may have better features, better characteristics in search, but sometimes we feel that Google Chrome is much better because it gives you better results. And basically, when you have an IP right, there are remedies also. As I said, it is civil action. You can get an injunction that is commonly known as stay. You have the interim stay and you have the permanent stay. You have go for criminal prosecution. There are offenses. For example, piracy is an offense which could be attracting a criminal prosecution. You can ask for the cost in litigation. You can ask for the enforcement division help, and you always have to be vigilant, and you have to be quite vigilant to protect your IPR. If you have written a paper, you need to ensure that no one is copying your paper and publishing it in their name. If you have made an invention, you need to ensure that the invention is always protected. So it's always necessary that you need to be vigilant. So when we talk about a single item may have multiple IPR embedded in it, and a camera, for example, there is a patent for every improved mechanism of a camera, and for its outside shape, contour, and configuration, you have the design, you have the trademark. For example, Canon or Nikon, all these trademarks are there, and then you have the copyright for the instruction manual, booklet, etc. So a single item may have multiple copyrights embedded within it, but then you need to choose which IPR is most suitable for you. And with that, I come to an end of my presentation. Thank you. If there are questions or any comments.
Thank you, ma'am. Now the session is open to all. You can just come up with your queries, or else you can just write it down in the chat box.
Thank you. Thank you. Yes.
So, thank you so much, ma'am.
Thank you.
May I audible?
Yes, you are audible, sir.
Yeah.
Yes.
Madam, myself, Dr. Anil Kumar Dular from Department of Environmental Science, University of Bikaner, Rajasthan.
Yes, sir. Good evening, sir.
So, Madam, you did the great deliberation with having all the dimensions regarding to this IPR. My simple question is, when you talk about some Rasgulla episode there, then I just having click in my mind that, ma'am, even we have so many geographical indications and geotaggings regarding to the product as an IPR, but still it is contradictory with many of states and beyond the states. So how can we resolve? So how can we resolve it? This is my question, because you tell. Madam, you tell that Rasgulla is between Odisha and this Bengal. It is between Rasgulla is between Odisha and Bengal.
Yes.
But ma'am, I am coming from this Bikaner. We have this wonderful asset being as a Rasgulla. So how does we claim? How does we claim for that?
That is what I would like to say. So I was in Delhi, from 2006 to 2021. I was in Delhi. And I think Haldiram, Bikanerwala, Agarwal, I would say Agarwal group, they have all have given Rasgulla. And Rasgulla is basically a milk sweet which is made with sugar, which is one of the most common sweet any region can make. But they have said that Odisha Rasgulla and Bengali Rasgulla, they have a very peculiar characteristics. If I'm not wrong, sir, you would be familiar with white Rasgulla, right? The small ones and the big ones.
Same here, madam.
Yes,
same here.
No, in Bengal, their Rasgulla is a light creamish yellow shade, and their composition of the gulla is different. The rest remains the same, but the combination of the things in that paneer is different. That's what they claim, sir.
Okay.
Yeah,
Then what about outside the states? Just I got the example. Have you heard the name?
You may approach the GI registrar with Bikaner Rasgulla.
because there is a problem regarding to methi. You know, methi trigonella phoeum gracium.
Yes.
Kasuri methi. You know, kasuri methi.
Yes.
Kasuri is the province that hails in, you know, in Balochistan, in the Pakistani province.
Yes.
And still the Nagaur, that is again in the Rajasthan, the people are struggling. And even they are only having the trademark, the Kasuri methi. Still, they are not getting this Nagori tag.
Sir, I think a better example would be basmati rice. We have the basmati rice from the Western India, Punjab, and the Eastern Pakistan, Punjab. Basmati is spread over the lower hills of Himalayas, the Western Himalayas, right? And both the countries share the GI. We have Pakistani basmati and we have the Indian basmati. And top of that, in America, Texas, a company there tried to grow basmati in Texas, one of the driest arid area, and they called it basmati, and India and Pakistan opposed it, and we made them change basmati to taxmati. I don't know how important it was, but the struggle is always there, sir, because a region like India, we don't know where it began. We have such a glorious past and glorious tradition of food. So it's very difficult to pinpoint, but we can always say that there is something which is relating to that particular area, which is contributing to that product. So just because there is Bengali Rasgulla and Odisha Rasgulla doesn't mean that we cannot have a Bikaner Rasgulla. Only thing is that you need to prove that Bikaner Rasgulla is different from the other Rasgullas, and it has an origin to that. It has a link to the geographical location.
Okay.
Yes.
Thank you so much. Thank you so
sir.
much, madam.
Good evening, sir. Any other question?
The discussion is open, so you can just come up with your queries, or else you can write it down in the chat box.
Thank you for all the appreciation and the kind words. Thank you very much, participants.
If there are no more questions, yeah, we have question in the chat box.
What do you mean by defensive patent?
Yeah, that is a question.
Yes. May I ask the person who have asked the question, defensive patent? What do you understand by defensive patent?
Sharavana Kumari, can you please answer?
Can you please elaborate on that particular thing?
Ma'am, good evening, ma'am. Very nice talk, ma'am. Elaborately you have given about everything. Just I want to know about what is meant by defensive patent. That is, this is one kind of patent. So it is about that is. I want to know about what is the defensive patent and what is the period of lifetime of the defensive patent.
Okay, let me first clarify that there is no different types of patent. We have only one type of patent, which could be for a product or for a process. Whatever the type of invention, it is a type of it is a patent only. But we call it a defensive patent when we are trying to defend our invention from any other particular category of any other industry which is trying to take away our invention. So, for example, multiple companies or multiple laboratories would be working on a particular type of medicine. So, if you are not, if you are not keeping watch on filing of your patent, the first one to file the patent will get a right. So sometimes you may be waiting for your invention to be complete so that you can get a patent, but by that time your other competitor might have already been patented. A defensive patent, on the other hand, basically means that you are defending your invention from others by using patent as a tool. It is the same term of protection, 20 years for any patent which you get under the Patent Act. But the only thing is that when we call it a defensive patent, it's like a defensive thing which you keep against your competitors, usually multinational companies or other industries. You file your patent because patent has this criteria that first to file will get the patent, not first to complete the invention. So people would usually file a patent application when they are sure that their invention is going to an end. I mean, the invention is going to be fruitful. They will immediately patent, regardless of the fact whether it is completed or not. So if you are not able to complete the procedure within 12 months, within filing 12 months, you need to give your complete specification. Your patent application will be rejected. So defensive patent is a patenting which you undertake to defend yourself against multinational companies. Because once your patent is granted or once you are filing your patent, it will be protected.
Okay, thank you. We have another question from Asmita Behera. Whether we can patent any ideas before any results or any product? That is a question.
You cannot protect anything as an idea form. You always have to represent it. And then what we need to understand is, even if you are in the last stage of your protection, you may be getting you can file your patent application, and this patent application will be considered once, the process is you file a patent application with a partial specification, that is partial description of your specific invention. And within 12 months, you need to submit the complete specification. So you can file a patent application without the completion of your invention, but you will only get a patent if you are filing your invention on time.
Okay, thank you. SR Senthil Kumar has raised a hand. Do you have a question, sir?
Yes, madam.
Okay.
Madam, good evening, and thank you very much for your nice presentation.
Thank you, sir. Good evening.
I
sir.
have one general question,
Yes, sir.
because your institute is exclusively for facilitating the IPR, right?
Yes.
The last year, how many patent applications your institute filed from government from the Kerala?
Sir, I think more than 40 or 50 applications have been filed, sir.
Then how many of them published? How many of them are granted, ma'am?
That I need to get back to you on that, sir. Maybe you can ask the person coming day after tomorrow. She is part
Okay.
of that facilitation cell. Dr. Asha is part of facilitation cell. She will give you the exact number. And I'll also
Yeah.
tell her, sir.
Yeah, sure,
Because
sure.
she's
madam.
part of the
Thank you.
facilitation center.
Okay, thank you very
Yeah.
much.
Thank you, sir.
Any more questions? No, I guess. Then we'll move on to the vote of thanks. I invite Dr. Mini Krishna, Associate Professor, Department of Physics, Vimla College, Thrissur, to deliver the vote of thanks.
Thank you, Shine. Am I audible?
Yes, ma'am.
Respected dignitaries and participants, greetings to all of you. It is with immense gratitude and a sense of accomplishment that we conclude the first day session of this 7-day online National FTP on emerging trends in intellectual property rights. This event is a true testament to the dedication, passion, and collaborative spirit of all those who have participated and contributed. I have been entrusted the duty of expressing gratitude to each and every one of you for being with us today. First and foremost, I would like to express our profound gratitude to Dr. Rajendran R., Deputy Star South Zone Mentor and Associate Professor, Department of Biotechnology, PSG College of Arts and Science, Coimbatore, for kindly consenting to inaugurate this National FDP. Sir, your thought-provoking inaugural address has undoubtedly enriched our understanding and instilled in us an urge to keep us updated on the various challenges one shall face in intellectual property rights and cybersecurity in our respective fields. On behalf of the college, on behalf of the organizers of this FDP, I extend towards you, sir, our sincere gratitude and respect. Dr. T. Shivakumar, Principal, RVS College of Arts and Science, Coimbatore, had been benevolent enough to generously share his knowledge and insights with the participants. Sir, the necessity of knowing the emerging trends in IPR was very well addressed in your keynote speech. On behalf of the organizers and participants of this week-long FDP, I heartfully thank you for your presence and keynote address. The very first session of this faculty enriching program was handled by Dr. Kavita Chalakil, Assistant Professor, Inter-University Center for IPR Studies, Cochin University of Science and Technology. I'm sure that her talk on intellectual property law and patent law has given the participants much insight on the framework for safeguarding intellectual creations, encouraging inventiveness, and ensuring fair competition in the ever-evolving global landscape. You gave a detailed narration, ma'am, on challenges and apprehensions related to intellectual as well as artistic property rights and various dimensions related to the same. I also appreciate the patience you showed in addressing the queries of our participants.
Thank you, ma'am.
Ma'am, on behalf of the organizers and participants, I would like to express my heartfelt thanks towards you for kindly consenting to be with us today and for sharing your expertise and insights in this area.
Thank you, ma'am.
Thank you.
Once
Dr.
again, I express
Dr.
my
Sister-
thanks to all organizers.
Okay. Thank you, ma'am. Dr. Sister Beena Juice, Principal, Vimla College, walks hand in hand with us, urging us to take up any endeavor that we wish to pursue. Her academic brilliance, along with the leadership eminence, truly inspires each and every one of us to go the extra mile for the benefit of the college. I wholeheartedly thank you, sister, for your motivational support and for gracing this occasion with your presidential address. I must mention the silent support behind the scenes by our vice principals, Dr. Tessina P. Immati and Dr. Malini K.A., for guiding us and being there for us to meticulously plan and execute every aspect of today's session and or the whole FDP ahead. My earnest thanks and respect to both of you for your timely intervention and advice that has really helped us to step over all the stumbling blocks in our path towards the smooth conduct of the event. From the part of the organizers, I also take this opportunity to thank Dr. R. Dhanabalan, Deputy Star College Scheme Coordinator, Department of Microbiology, RVS College of Arts and Science, Coimbatore, for welcoming the participants to this endeavor. My heartfelt appreciation towards Dr. Sister Sylvie Matthew, Deputy Star College Scheme Coordinator, Vimla College, for taking pains to coordinate this event in the most beautiful way possible. I would, at this juncture, specially mention the dedication, planning, and tireless efforts put in by the organizing and technical committee of Vimla College, along with the collaborating partners of this academic venture, both RSV College of Arts and Sciences, Coimbatore, and Inter-University Center for IPR Studies, CUSAT, which has truly made this event a reality. I would also like to express our sincere appreciation to all the participants who have joined us today online from different parts of India. Dear participants, it is your active engagement, enthusiasm, and eagerness to learn that has created an environment of vibrant knowledge exchange and peer learning. Expecting your sincere cooperation in the days to follow and desiring the very best towards the success of this event, and wishing you all the 76th Independence Day wishes in advance, I conclude. Thank you all.
Thank you, ma'am, for your warm words. So with this, we are moving to the close of today's session. Sister, do you have to address the gathering? Do you have something to say as a close note?
Yeah, nothing. The session was very nice. I am very thankful to Dr. Kavita.
Thank you.
A very informative session, ma'am.
So, okay. So once again, let me thank all the delegates. Sir, Rajendran, sir.
Yeah, I have a few words to say.
Okay.
You know that Dr. Kavita's presentation and the way she was able to do it was something exemplary, and you can find that every small thing that was associated with IPR was very clearly being deciphered by her. So my congratulations to you, madam. And I feel that being a coordinator of this Star College scheme on an all India level, being the task force member, I want many of the colleges throughout India to have the advantage of having your talk, and I would like to invite you to give a talk to all India, everybody. The
Thank you so much.
Okay.
Thank you, sir.
Thank you.
Thank you so much, sir.
And I thank the organizers also for this event.
Thank you, sir. Thank you.
Thank you all. Let me thank you once again from the bottom of my heart on behalf of Vimla College, Shu. So let us meet the next day, same time.
And I'll be meeting the participants on Friday, I think, with the session on plant variety.
Yes.
Okay, ma'am.
So let us sign off for the day.
Good evening.
Thank you once again and good night.
May I leave the meeting?
Thank you.
Oh, yes.
Thank you.
Yes.
Yeah.
Thank you.
Thank you all.
Thank you, sir. Thank you.